Hey, what's up, y'all? This is David with I'm So Offended. It's been a minute. Um, I actually just finished trial. So, yeah, I'll, once I get the tape, I'll, uh, I'll put it up and we'll talk about it. So, but some of you guys that I spoke to, I told y'all that I was going to trial. And, yeah, going to be transparent, going to upload my tape of how it all went, and you're going to hear me in action in court. All right. But as far as this video here is, I find myself getting like a lot of the same things are happening with some of you guys, and so I felt it needed to be addressed so that way you guys aren't digging yourself into a deeper hole. So, gonna say for the record that um, I'm not a lawyer. I don't practice law. Um, and none of this is legal advice. This is all for entertainment and um, education, educational purposes only. And I'm not liable for anything it is you do. All right. So what we're doing here is we're going to talk about as far as when you're getting faced with contempt of court, rule to show cause, motion to enforce. I mean, they're all the same, but they're not. They're kind of like a box of a bunch of the same things, but they're kind of separate. So we'll take a look at those. And the reason why I have to mention this is because um, you guys saw my videos. I beat contempt. Okay, I beat contempt of court. Right. I've actually beat contempt of court like 3 times now. To be honest with you, they've found me in contempt, like on the record, where they said like, "Oh, you're found in contempt." I've been told that like 3 or 4 times now, but I've never spent a day. Um, so I want you guys to understand that first of all, you can't just file a special appearance and put in for a modification. Like I've talked to like a couple guys, and you guys are filing modifications, filing a special appearance. No, you cannot do that. You can't do that. Okay, and I'll explain this in another video. But basically, what this is about is do what I did at your own risk. Okay, because I've talked to guys and I've prepped them, for contempt of court. One guy in particular last year, um, and they incarcerated him. He had all his paperwork. He invoked his rights properly. He did what he needed to do. They incarcerated him. The thing is, he paid the purge. When you pay the purge, you're you're showing that you basically have the ability to pay, right? So yeah, it sucks to be incarcerated. Yeah, it sucks to be away from your family. All of those things suck. But he had only been detained 2 days. Okay, and pretty much the police, any law enforcement can detain you for like a day or two, just to investigate. Like if they have probable cause and they investigate, or whatever, and then they let you go free. You know, so he spent like 2 days and he paid the purge, and all of our work was for nothing, and it really sucked. It really sucked, but I understand what he was going through. He was away from his family, and he didn't want to be away. It was during the holidays, and I get it. I get it. I didn't want to pressure him. I didn't want to do anything like that, but um, he paid the purge, and so at the end, he didn't beat the contempt. At the end, he ended up giving consent. At the end, he just did what they told him to do. Okay. And, um, sometimes it works out like that. sometimes it doesn't. So make sure you guys are fully aware that I'm not responsible for what you guys do. However, I went into my contempt proceeding um, with basically with no regrets, with no fucks given, with nothing to lose. Because what I did is I had asked my sister and appointed her as power of attorney. I had saved up some money. I had given her all the information on my bank accounts and bill pays and everything. And I was like, nope, I'm gonna go into this expecting that I might go to jail. So I was ready. I was ready. So I went in with zero fucks to give, with nothing to lose. A man that walks into court with nothing to lose has everything to gain. So that's how I walked into my contempt proceeding. As far as if you guys are being faced with a contempt and a rule to show cause and whatever, in all of those documents it tells you how to beat them. Okay, because they invoke rules, and in those rules it says how to beat them. It's there. I've shown you several videos of how I do this. Several videos that they serve me with the document, or I have a document and they're invoking a rule. I read the rule and it gives its procedure and defenses, and I keep winning. So what I try to do is whenever I talk to you guys, like I show you how I get the information, so that way I can try and like not just tell you what to do, because legally I can't do that. I don't do that. So I show you guys. I take you guys to the water fountain so you can drink and keep living. You know what I mean? Like that's what I do. I want to help you guys also be able to take care of yourselves and do this for yourselves. All right? So, do not do what I do unless you're fully prepared to go all the way. All right? Like, unless you're fully prepared to go all the way. So, all right, we're going to look at contempt of court. So, contempt of court, simply referred to as contempt, is the disobedience of an order of a court, additionally conducting conduct tending to obstruct or interfere with the orderly administration of justice, also qualifies as contempt of court under Federal Rules of Civil Procedure, Rule 70. A party that fails to perform a specific act in accordance with the judgment by court can be charged with contempt and subsequently penalized. The purpose of recognizing contempt of court to secure the dignity of the courts and the uninterrupted and unimpeded administration of justice. So when you're in court for contempt or rule to show cause or those, you're not there because you didn't pay child support, or you're not there because you didn't produce your kid for custody. You're there because there's an order and you didn't follow it, which is why they can get away with incarcerating you over money, because it doesn't have to do with money. It has to do with you having to follow the order, okay? Because they already assumed that you could pay when they entered the child support order. When they entered the child support order, they already assumed that you can pay. So if you're not paying, they're not incarcerating you for not paying. They're incarcerating you for not following the court order. And what's the court order? To pay the child support. Okay? You with me? So, contempt of court is direct or indirect. We're not going to focus on direct because that's not what we're doing. Direct is basically if you call the judge an asshole. That's direct contempt. Indirect contempt of court is any contempt that does not fall within the direct contempt, right? So it's failure to comply with probationary orders outside of the court as an indirect contempt of court, or a person charged with indirect contempt. And it says a person charged with indirect contempt must be given notice and an opportunity to be heard, right? There's due process. Because guys will send me emails and say, hey, they violated my due process right. All right, did they let you know about the hearing? Yeah. Okay, did you get to explain yourself at the hearing? Yeah. They follow due process. What are you mad about? He's like, well, I didn't know. I was like, you know, I this is an analogy I use with you guys when I talk to you guys. Um, all right, so I live in Arizona. The highway speed limit is 75. So if you're traveling on the 10 to California and you cross over into California, the highway speed limit is 70. Okay, let's say you miss the speed limit sign. You're still going at 80, whatever. You get pulled over, highway patrol, and they say, hey, do you know how fast you were going? It's a trap, basically. You say you don't know, but it doesn't matter. It doesn't matter. It's like, oh, I clocked you at 80. Speed limit is 70. And then if you tell them, it's like, well, I was in Arizona just now. It's 75. He's all like, well, in California, it's 70. And then if your response is, well, I didn't know, here's your ticket. Now you know. Ignorance of the law is not a valid defense. Oh, I didn't know. I didn't know. Here's your contempt of court. Now you know. Oh, I didn't know. I didn't know that if I signed the birth certificate, I'm going to have to pay child support and have my bank levied. Here's your warrant. Now you know. It's fucked up like that. But I want to be very clear. All right? So, they are coming after you for failure to follow the court order. So, there's civil contempt and criminal contempt. So, and it gives an example. In Pennsylvania, if a court's purpose for finding contempt is to coerce the contemptor to comply with the court orders, then the charge will be one of civil contempt. However, if the court's purpose is to punish the contemptor for disobedience, then the charge will be one of criminal contempt. In New York, on the other hand, the purpose of civil contempt is to protect parties' rights to litigation. Any penalty imposed on the contemptor is meant to protect that right. Similarly, criminal contempt is used to protect the judicial system, but is generally meant to recognize an offense against public justice as opposed to a litigant. Procedure and punishment. It's a good thing that it says these different states, because it is different with the states, but each state has their rules, and all you got to do is look up their rules because it's going to be right there in the motion they filed against you, or technically it's a lawsuit. They file a lawsuit against you for failure to follow a court order. So classifying contempt is as important as different categories of contempt can carry different procedural safeguards and punishments. In Michigan, an individual charged with criminal contempt is afforded some of the same rights as a criminal defendant. Among other things, they are presumed innocent, have the right against self-incrimination, that's the Fifth Amendment, and contempt must be proven beyond a reasonable doubt. On the other hand, civil contempt requires only basic due process protections. As such, the individual need only be given notice and opportunity to be heard, and the burden of proof is a preponderance of the evidence, which is when they ask you for all your financial data. Yeah, that's the preponderance of the evidence. Punishments for contempt include imprisonment and fines. However, according to the Supreme Court, civil contempt penalties are conditional. One who is punished for civil contempt can avoid the punishment by doing so as the court order is therefore described as carrying the keys of their prison in their own pocket. Punishments for criminal contempt, however, are generally unconditional and definite. So carrying the keys of the prison in their own pocket, which is why they issue a contempt purge. They issue a purge. Pay this amount of money and you won't go to jail, which means that you can literally pay your way out, which is also an injustice to where that means that these crimes are basically only designed to benefit the rich, because the rich have money and the poor might not have it. However, they have to prove that you have the ability to pay. But anything short of indigent they will seek to incarcerate, because if you're not indigent, then that means you have the ability to pay. Wherein lies the classes. The classes as far as poverty, middle class, whatever. So anything above poverty. So you could be middle class, and the middle class gets fucked royally in this country. It just gets fucked, and somehow the middle class has been led to believe that it's the fault of the poor people. Meanwhile, none of you guys are blaming corporations. You want to blame Biden, you want to blame Trump, whatever. It's the corporations that own all of these people. Inflation is because the corporations are basically making record profits. That's not Biden's fault. That's not Trump's fault. Although Trump did give tax cuts to the rich. So there's that. Do with that information what you will. Criminal contempt. So notice must be given in an order to show cause or in an arrest order. State the time and place of trial. Allow the defendant reasonable time to prepare defense. State the essential facts constituting the criminal charge against and describe it as such. They appoint a prosecutor, and there's a trial and disposition. A person being prosecuted for criminal contempt is entitled to a jury trial. In any case in which federal law so provides, must be released as detained in Rule 46. Criminal contempt involves disrespect toward or criticism of a judge. That judge is disqualified presiding at the contempt hearing or hearing unless the defendant consents. So, punishment is basically just how it's laid out. So, what I did, I beat the contempt, right? It was in defense of what they brought against me. If you're going to file a modification, you can't file a special appearance for that. You filed for it. You can't give the court jurisdiction to do something and then show up and challenge jurisdiction. You can't do that. If you file a motion for something, the court can only address that particular motion. If you file a petition for custody, let's say, right? And they want to talk about child support, you don't have to talk about it. They can't force you. They'll try, but they can't force you. You know how I know this? Because I've been going to court for custody for years now, and every time they talk about it, I keep getting that dismissed. I keep shutting them down. Like, my lowest view count is the motion in limine, and that might be the most important document in all of my videos. Like, y'all have no idea. The motion in limine has shut down any discussion of child support in all of my hearings. Like, all of them, except the contempt, because they filed that, right? But in anything I've filed regarding custody, anything they filed regarding custody, anything having to do with it, I've shut it down. And I actually just used it again. I literally just used it again last Friday when I had court. So review that. Anyway, I'm going to end this one right now, and I'm going to do another video on petitions and motions. But just understand, what I did was beat contempt in defense. My position was of defense. Okay? You cannot use a special appearance for offense. Okay? You cannot file a petition and use a special appearance. Do not file for special appearance if you filed a petition. Yes, that's exactly it. Do not file for special appearance if you filed a petition. All right.